appeal in the matter of Cobalt Data Centre LLP and the Commissioners for His Majesty's Revenue Department.
Yes, Mr. Jude. As you see, Lord Justice Newey is joining us remotely.
Yes, fantastic. So we're going into this gently, not fully in court, but partly. It's very nice to see you all. My lords and my lady, I appear in this appeal with Mr. Cosman, Mr. Waldegrave and Mr. Alexander for the revenue, and Mr. Williamson, Ms. Shaw and Mr. Jones appear for the LLPs.
Yes.
I was rather hoping they'd all be sitting in the front row. Just to,
well, they can by all means, whatever suits them best.
This is an appeal and a cross appeal.
Yes.
And you will have seen that although they arise out of the same transaction, the issues are quite separate in the appeal and cross appeal. And therefore, if you've had a chance to look at the timetable which we propose.
Yes, we have. I should tell you that we've obviously read both decisions of the Upper Tribunal. We've read the various skeleton arguments. We've looked at the documents in the supplementary core bundle. I'm not stopping you from taking us to them,
yes.
But we have looked at them.
Yes, that's.
I can't say that I've read every word of the JCT contract, I have to say, but I've read what I think are the relevant parts.
Yes. I was going to say later that there are only a very few documents that are relevant to the appeal, but some of them are quite long.
Yeah.
Although not as long as they seem, because there are a lot of annexes which are actually probably not very relevant. I'm sorry, I apologise to Lord Justice Newey. I probably won't be looking at you very often because it's very difficult to swivel round, but I haven't forgotten that you're there. So we have the timetable. I certainly feel we'll keep within that and see how things go. Then we have the bundles. You've seen you have all the bundles, I hope, including 3 bundles of authorities.
Yes.
Most recently, and there's also a plan which we provided. What I can do is
I'm not aware of that.
This was a plan of the site annotated, which was handed up, I think, in fact, by the LLPs at the Upper Tribunal.
This is sites A, B, and C, is it?
A, B, and C, and it also shows you where DC 1, 2, and 3 were built.
Right. Do we find
yes,
that?
It was sent. I hope Lord Justice Newey has it. It was sent by email.
I do, thank you.
Yes. Can I hand up perhaps some hard copies if I can find them?
I'm afraid it passed me by. If it was
I can hand up
I haven't seen
these 2 for the court. I think. Have you got?
Yeah, we've got a spare copy if you need.
It's very useful when looking at the what happened, the contracts, to look at this diagram. I think
right.
It shows you where everything is.
Thank you.
It is based on a diagram that is in the bundle, but the diagram in the bundle is very difficult to read because it's faded, so you can't tell what the colours are. So I'll come back to this when I come to look at the part of the decision. But you can see that you can now see where site A, site B, and site C are.
Yes.
And the first general point to make, this may seem obvious, but this is a tax appeal. And in my submission, the arguments, which certainly we'll be putting in the appeal and probably in the cross appeal, do not touch in any way upon the commercial agreements under which the building was constructed to shell and core and will in time perhaps be fitted out. I'll show you that as we go through, but those are separate from the arguments that we're having today, which are really rather narrow. Now my plan of submissions is as follows, my lord, subject to the court. I was proposing to start with some context, looking at the genesis of the arrangements of this sort. We can find that in part of the Upper Tribunal decision, which I'm sure you've read, but I was just wanting to take you back to it. And then I was going to look at the chronology of events from the decision with the aid of this handy plan, so that we can see where the various things happened and where they were supposed to happen. And then I was going to, those 2 things shouldn't take too long, and then I was going to look at the documents, again, not at great length, but I was going to point to the relevant parts of the documents and try and explain how we say they all fit together. And then I was going to turn to the legislation. That should be fairly short because there are only a few provisions, and it's very well explained in the Upper Tribunal decision, in fact, as to how the various provisions fit together and why we're looking at not only the expenditure incurred by the employer under, it said, the Golden Contract, but also the expenditure incurred by the LLP, which was a separate matter.
Yeah.
And it is in fact only the expenditure incurred by the LLP upon which capital allowances are claimed. But it's necessary for the expenditure incurred by the employer to qualify in order for the expenditure by the LLPs to qualify.
Yeah.
You may have picked that up. And finally on this, I was going to look at the authorities, and these are all authorities on the Morris and Barron line, and explain what we say was decided by these cases and why the Upper Tribunal was wrong in what it said about them. And then finally turn to my submissions. First of all, the proper construction of section 298. What kind of contract does it have to be within a 10-year period? Then the clause 12 issue, which is, you will be aware, is a respondent's notice issue. But I need to say something about it because it does interlock with the other arguments. So I was going to say something about it, but not everything, and I was proposing then to reply to what my line of friends says.
Right.
And then finally, issues about the submissions on the new contract issue and rescission. Now that seemed like a logical sequence. I'm not sure it was the exact sequence that was adopted by the Upper Tribunal or indeed in our skeleton, which I think followed the Upper Tribunal.
Yes, well that's sort of chronological order, isn't it?
It
in
is.
which the points arise.
Exactly, yes. Yeah. So, can I then, without more ado, turn to the question of context? And to do this, I'd just like to take you to something which is in the Upper Tribunal decision, because the genesis of these arrangements can be found in discussions with the revenue in the 1990s. So if I can just... so if you just turn out paragraph 300 in the Upper Tribunal decision. Sorry, this is part of the judicial review.
Yes.
Which is no longer live issue.
300.
It's paragraph 300, which is a description of correspondence and discussions that a body called the Enterprise Zone Property Unit Trust Association, HISPUTA, had with the Inland Revenue at that time. And it was Mr. John Watson, slightly confusingly, there's another Mr. Watson involved in this case, who's one of the experts, but this is Mr. John Watson, who is a very experienced solicitor specialising in this area. He acted pro bono for the association in corresponding with the revenue. And you'll see from 301 that one strand of the correspondence focused on what we term greenfield site issues. Now, this wasn't relevant, as the Tribunal goes on to say, to the judicial review, but it was the background to the and part of the evidence that was in the judicial review. The greenfield site issue was what happens if someone is buying a site which hasn't been developed yet, but which is going to be developed from a developer, where there is a contract already in place to build the building. Can they claim allowances in that circumstance?
Yeah.
And the discussions on this issue you'll find set out beginning at paragraph 320 in the decision.
Yeah.
In parallel, ongoing correspondence written greenfield site issues. And then you can see below that is what Mr. Watson wrote. And this is the if you like, the paradigm case. This is the case that he's putting to the revenue. If this kind of thing happened, would allowances be available? And so he says he assumed for the moment the golden contract between a developer and a contractor, total consideration is a single lump sum payable before building commences. Then the contract's entered into the following things that occur. It's agreed to begin work, so the lump sum becomes immediately payable under the golden contract. The developer pays the lump sum. The developer is now entitled to have the building constructed for no further consideration. The developer transfers to the trust its interest in land with the benefit of its rights under the golden contract to have the building constructed. Work begins. So it's a very straightforward situation. There's a building contract within the 10-year period to build a building. They pay up the front, and then they assign the rights under the contract to whoever it is that wants to come in, and they take over and claim the allowances on the amount they pay. And I think the difficulty that was perceived at the time was you only get allowances, as you will have seen, for expenditure on a relevant interest. And it was thought perhaps that had to be an interest in land, if you like, or interest in the building, a constructed building. But the revenue confirmed in this, and it's common ground, that you can acquire a relevant interest in a building by acquiring a contract to build the building by assignment.
Is building defined in the Act? I couldn't see a definition.
I don't know what it is, in fact.
There are two things that weren't defined were building and developer.
Yes, I think.
Developer, I think, was defined for a later assessment period, but not during the period with which we are concerned.
Yeah.
And although there is a section which tells you to strip out the cost of acquiring land,
Yes, that's right.
doesn't seem to be a definition of building.
No, I think, yes. I think it's assumed that the building is the thing that's on the land, it's sort of physical.
And separate from the land.
Treated for this purpose as separate from the land, or at least, I suppose one way you could acquire the building is by acquiring the land, but you would then have to do an apportionment between the amount you were paying for the land underneath and the amount you're paying for the building.
Yeah.
Not an easy exercise, perhaps, in some cases, but I think you're right. Well, the assumption is that it's a building, the real physical thing. So if you bought a constructed building, then that would qualify, as long as other conditions were satisfied. Yeah. But equally, if you acquire by assignment the contractual rights, that's the acquisition of a relevant interest. Yeah. And the relevant interest, I think, in the present case, as I understand it, was the right to have the building constructed and fitted out under the contract.
Yes, well, that's certainly what the UT found.
Yes, that's right. But we'll see, in fact, there's a bit of difficulty with that because the UT didn't distinguish between constructing the building and constructing and fitting out the building. Because, of course, it's only the construction phase that went ahead initially. And we'll see that there's a difficulty. One of the difficulties in the change order is that it only actually instructs the construction of the building, not the fit out.
Right.
But anyway, we'll come on to that. But I think it's important to understand what the revenue we're talking about. And then it's also interesting to look at paragraph 321, because Mr. Watson there is raising another difficulty he foresaw, which was supposing often these contracts, in fact, will be contracts where the consideration will be paid in stages. And so in order to get into this scenario, you would have to vary the contract, the building contract, so that everything was payable up front. And the question that was being raised in this exchange was Mr. Watson was concerned that might be sufficient to create a new contract because it might be sufficiently, might be sufficiently, might be sufficient change. You can see, Mr. Watson, I would suggest, is applying the orthodox view that everyone's always had in the past as to how you decide these questions of whether there's a new contract or whether there's rescission or whatever, which is you look at the extent to which there is a change between the original contract and the new contract. And his concern was this might be sufficient. I think the revenue reassured him that probably, in most cases, that wouldn't be the case. But of course, every case turned its own facts, so they weren't prepared to say for sure. But it wasn't the problem. But it's simply interesting to see at that stage, clearly there was no suggestion about golden contracts and varying contracts had been entered into, etc. none of that is part of the, if you like, the revenues involvement in this case. It's much more straightforward. You have a contract, you assign the benefit of it. It's all paid up in advance. You assign the benefit of it, and you can claim the allowances. And it's also interesting to see the orthodox view being taken by both the advisors and the revenue at that time, and that's reflected in a tax context in the Shell UK case, which we'll come on to look at, where the special commissioners adopted a completely orthodox approach to the question of whether there's a new contract in that case. Yeah. But the Upper Tribunal didn't approve of that. You'll see in this decision. They thought it was wrongly. They thought the special commissioners were wrong on that. So that is, if you like, the genesis of it. But by the time we get to these arrangements, they've obviously developed, as these things often do, to be a bit more and more pushing the envelope. So then, can I take you to the chronology of events in relation to this particular EZE site? And that's set out paragraphs 31 to 46 in the Upper Tribunal decision.
Yeah.
And you can see a bit of the history of it in 32 and 33. It was owned and operated by Siemens, and I think, be corrected if I'm wrong, but I think that is the building that you can see on the plan on the right-hand side. The right-hand side of DC1 and DC2. That is the Siemens building.
Yes.
And then the Upper Tribunal go on to discuss the golden contract. And they set out describe the various works options. Which relate to different sites, and we can now see from this plan clearly where sites A, B, and C are. In particular, you can see site A is in fact the whole of the bigger area, edged in green. Site B is a smaller area and within it in yellow, bottom, and site C is the purple in the middle, where DC1 is. And site C is quite important because that is the site that works option 1 related to.
When was DC1 built there?
Sorry, Mother?
When was DC1 erected on Site C?
I was going to come on to that.
I guessed you were, but
yes.
Just give me a ballpark.
You can see paragraph 62 of the decision. 20th November, the change order 1 was issued under the golden contract, and referencing works options 1 and 3, and requiring to undertake the construction of the data centre, and then it was built thereafter. I think
that
it was
DC1,
built between 2010 and 2012.
Right.
So it was just before, I think it was built up to 2011. It was just before the change order for DC2. And of course, the reason it's dealt with in the decision, of course, is it was under the same contract.
Yes.
Yeah. So then you can see the description in the Upper Tribunal decision, paragraph 36, the golden contract.
Sorry, I just haven't quite understood that. Originally, the UT found, and I don't think there's any challenge to this, that the developer had to pick one and one only of the work options. Then
that's right.
They talk about the variations, which they refer to in 61. So change order 1 references work options 1 and 3.
That's what seemingly it did, yes.
So does that mean that the right to select options under the contract has now been exhausted?
Well, yes. Just winding back 1 second. Before then, of course, there were two variations which you have seen in 2009, which allowed you to select a combination of works options.
Yes, well, that's what those beauty are referring to in 61.
Yeah, that's 1 and 3. So, well, then the question, yes. Well, this is what we're going to be will be clearly part of my submissions as to what the consequences are of all these events. But it's quite difficult to really understand exactly what was intended to happen.
We've got the variation agreement number 2 in one of the bundle D, I think.
Yeah. What
that seems to be suggesting that the developer can have 2 options, 1 and 3.
Well, in fact, more than that, because he has 3. DC3 was also built. In this case, there were 3 buildings built, it is said, under the Golden Contract.
Well, I follow, but the question is, are they all built under this contract?
Yes, that's exactly the question.
So well, all right. If the developer under the contract can select 2 options, which is what I understood the 2 variation agreements to entitle the developer to do, and change order 1 has in fact selected 2 options.
A combination of options, yes. And the building was then built. Yes, exactly. I mean, it's all very puzzling because we'll come on to this in detail later. But change order 2 was purported to be under works option 1, which of course was impossible at that stage because DC1 had been built on the site. But what it then said was that you didn't build that. You built something completely different. That was on a different site, which was DC2. And then the same thing happened with DC3. It also was a notice to proceed under works option 1, but was to build on a different site again, DC3, where DC3 is.
But if works option 1 had already been selected in 2009 by change order 1, difficult to see how it could be selected again by change order 2.
Yes, well, I agree with you, Lord. But it's also difficult to see how any works could be directed thereafter. Because as you rightly say, the contract, and we'll look at that, but the terms of the contract are quite clear that it is 1 works option. I mean, it's an alternative. You choose one of an alternative. So it's not a contract for more than 1 building project. It's a contract for 1 building project.
Well, so I can see how, Mr. Hewitt, that as a result of the variations, you've got 6 options. Variations seem to allow the employer to select 2 of those 6 options.
Yeah.
But presumably they've got to be 2 compatible of the 6 options, because you can't have both of them being built in the same space when there isn't room for 2 buildings.
Yes. Well, and also there are only 2. There are two variations, and they allow particular combinations of options.
Exactly.
Not any combination.
Exactly. So you've got to pick any 2 that are compatible.
Of the ones they've
yes,
allowed.
of the ones they've specified.
Yeah. Yes. But the problem is that it's a necessary part, really. We would submit a necessary part to make any sense of all this. That at some stage, either under DC1 or DC2, the variation was a variation not just to build something different on a different site, but was to change the contract to a contract that could have more than 1, and indeed an infinite number of building contracts under it. So it's altering the nature of the contract. Fundamental nature of the contract must have been altered. There's no really other explanation for this, because as you say, otherwise, under the contract's quite clear, you can only build 1 or 1 combination, and after DC1 that's happened. But anyway, we'll come on and look at the change orders in more detail. But you're right, my lord, that is a fundamental problem. I think just by looking at this plan, you can see the problem.
Right.
So then, that was exactly the point about the one option, was the point I was going to make in paragraph 36, I think is the reference. And then clause 12, this is the which permits changes in the employer's requirements. And then we have the 2 change orders,
Yeah.
which occurred in 2011. And then after that, 3 days after one and on the same day as the other, 3 days after that in DC2, 3 days afterwards, we have the SDA, the Sale and Development Agreement.
Yeah. If you look at the employer's requirements as referred to in the change orders, they say that the contract's going to be executed as a deed. Couldn't see that in the chronology anywhere. Did it happen?
Don't think so. No, I haven't noticed that. No, you mean the contract to build?
Yeah.
The subsequent contract?
Yeah. The oops.
I think it's in
Go
beginning of
to
C.
Bundle D, tab 36, at page 1286. Well, you start at 1276, which says Employers' Requirements Contract version January 2012. And
I'm
then
sorry, which
tab
page?
36 in Bundle D.
Yeah, that's the employer's requirements, yes.
Yeah, so those are the employer's requirements. And then if you go to clause 1.12, that tells you the form of contract is going to be the JCT contract with amendments. And 112.2 says the agreement will be executed as a deed. But I couldn't see any sign of that either in the chronology or, for that matter, in the bundle.
Yes, I mean, the contracts that are being referred to here, I think, are the contracts with the subcontractors.
Ah, okay.
The subsequent, because this is a document for the benefit of the subcontractors.
Oh, I see.
Is this the document, because one of the things that you told us is that some of the documents are missing,
Well,
as between the contractor and the subcontract. As between the up the line, and so all we've got are the subcontractor documents, and an inference was drawn that they were back to back. Is that right?
well, I think it's not quite as simple as that.
No.
What we don't have, what the LLPs weren't able to provide, was what's called the draft employer's requirements, which is referred to in the change orders.
Right.
So, and you might have thought that was quite an important document because they rely entirely on the change orders as being the change. Anyway, we don't have that. They couldn't find them. There was some evidence from Mr. Pulford. We'll perhaps look at this passage in the Upper Tribunal decision, where he said that although he didn't really look at these contracts or didn't have anything to do with them, he thought that they're likely to be similar.
The UT weren't terribly impressed with that.
They weren't impressed by that, but they then said, well, it doesn't matter because we'll just look at what was built. And I've something to say about that. We don't say that's right or satisfactory. So, but this is in fact the document produced under the SDA, which is the framework for constructing the building, the commercial contractual framework for constructing the building as opposed to the tax documents. This was produced, as I understand it, although it's rather confusing, it talks about contractors and whatever, but I think it's from the contractor to the subcontractors, asking for them effectively to quote, I don't know exactly the process, but these are the specifications they want built, and they want the subcontractors to build them. It's only, you'll no doubt have noted, these are only in relation to the construction of the shell and core. They don't deal with the fit out at all. Now that's for an obvious reason, which is until you've got a tenant, you don't know what fit out you need. And so the presumption was, what was assumed was that until when they got the tenant, then they would decide what the fit out would be, and they they would intend
Yes,
to fall
because
in that stage.
each tenant would have their own specific requirements in terms of what data they want to keep, how many computers, whatever.
Yeah, exactly.
Yeah, exactly.
Yeah, and also things might have changed in 10 years from when they built it to when they might. I'm not sure it's been let yet, but I mean, it's going to be a long period, but no doubt technology has moved on since then. But yes, it's only for that. And just while we're at this, if you look at page 1442, you will see this is the contract sum analysis in relation to these employers' requirements.
Yeah.
And they come to 15 million. You'll see at the bottom.
Yeah.
And I think I'm right in saying that's a little bit less than what the contractor was nominally being paid for this, which was, I think I read somewhere 18 million. So there is a big problem, as you rightly say, when we look at the change orders, which are referred to in paragraph 37, that critical document isn't there. But I think we can assume that, as with that it would only deal with the construction work. And we can assume that because when we look at the change order, that's what it deals with. So you can see the sale and development agreement is described in paragraphs 39 to 46.
Yeah.
Some parts of it are not relevant to this appeal, but they will be relevant to the cross appeal because they relate to the other arrangements that were entered into around about the
Capital
various
support.
security arrangements, the
Yeah.
capital support, etc. These arrangements. But in my submission, when we look at that document, you will see that you don't need to look at anything else. Nothing else is required. There are obligations on all the
When you
relevant
look at
parties.
which document? The SDA?
The SDA, yeah. You'll see that there are obligations imposed on all the relevant parties to construct the building, indeed to do the fit-out work when it actually came about. So that's all dealt with as well, although not only in draft, if you like, at that stage. But the whole thing is dealt with under the SDA. So the questions of what happened on the 1st of April under the change order, we would say are of no practical commercial importance whatsoever. Whether the change order had any effect at all makes no difference whatsoever to the commercial position of the parties. Of course, could make a big difference to the tax position. That's why we're here. But I thought I ought to make that clear that it's not a question of the commerciality. Could I then take you to the documents, the relevant documents? And I was going to start with the golden contract, which is obviously important, which is in bundle B.
We're now going to core supplementary.
I'm afraid I've been using it in the non-core supplementary, but I think it would be the same. You've been reading in the core. I'm sorry, ma'am.
I've been using the supplementary core bundle. Tab 1 has the JCT and tab 2 has
Right.
the amendments.
Well, can I refer to the paragraphs then?
Yeah.
Yeah. Now, this seems to be the standard way building contracts are done, but it's rather difficult, awkward, to work out what actually is the position, because you have two documents. You have the standard form, and then you have the document amending it.
Yeah.
I think, and I keep changing my mind as to which to start with. You could start with the standard form and then look at the amendments, or you can look at the amendment. I think it's actually better to look at the contract, the amendment, document, because it is quite substantial in this case. It's not simply amendments. So if we start there, and recitals A, B and C were regarded as important by the Upper Tribunal when it came to looking at the issue on clause 12, you may remember.
No, wait a minute, sorry.
So the recitals, which are...
Yeah, no, I'm missing the recitals
We're
A and B.
missing those.
Mine starts at D. So,
Oh, I'm sorry.
so where do I find the other?
Yeah, it's on bundle B, supplementary.
Well, what I'll do is I'll just take out that page.
I think that's the only
Yeah.
thing. that
Tab?
It's on page, tab 20, page 542.
Right. Yes, I'm just missing that page. Take it out.
So,
Yes.
so it begins, the first recital, employer wishes to obtain the design, construction, commissioning, if any, not very confident at the start, of the works detailed in either, and then works option 1, 2, 3, 4, 5, and then, unfortunately, the punctuation has gone slightly wrong. It seems to be a feature of this document that sometimes works options 1, 2, 3, 4, 5, and 6 are just placed without any punctuation between them at all. You'll notice that in other places. But I think there should be an or before works option 6
Yeah.
to make it correct grammatically. And then the employer's issued requirements in respect of each of them, which are Appendix 14, 15, 16, 17, 18, 19. And then it says the contractor has examined the requirements and submitted proposals for carrying out the work. And then C, the contractor has carefully examined the employer's requirements for each works option and satisfied that it shows and describe the works in sufficient detail to enable them to prepare the proposals, etc. So I think the point the Upper Tribunal were making is that this shows that the contractor's done all the work, very happy with what's in this contract. But you wouldn't expect, under this contract, the employer to be able to completely, unilaterally, under clause 12, completely change what he's asking the contractor to build.
Produce works option 7, effectively.
Works options, yes, exactly. Produce a completely different works option. And a completely different price, of course, which is actually, in some ways, more important.
Yeah.
And then if you turn on, I hope you have the next page, my lord, the articles
Yes.
of agreement. And Article 1 is the basic obligation. The contractor will, for the consideration mentioned in Article 2, be responsible for the design of the works which has already been carried out. I think that means the design has been carried out, not the works. As at the date of this contract, and whether such design is the employer's requirements of the contractor's proposals, whom for it's carried out, and carry out and complete the construction of the works. And the works, if we just move forward to while we're there, to the definition, that's on page 551, or in the definitions, it's about 6 or 7 pages further on. Works means the design, construction, commissioning the employer wishes to obtain for the works option stated in the notice to proceed, which for the avoidance of doubt shall be either works option 1, 2, 3, 4, 5. In this case, they have got or 6 referred to in the employer's requirements. And it's that, and then the definition of works option, which means works option 1 or 2 or 3 or 4 or 5 or 6. And while we're here, you can also see the definition of works option contract sum analysis, which is something that seems to be typically contained in the employer's requirements.
So at that
we
stage,
saw.
it's basically a choice between one of each, one of the 6.
Yes,
One,
exactly.
and it's got to be that one.
Exactly, and that's what all of these provisions demonstrate. I think that's right. So if we turn back to Article 1A, which is back earlier on, the agreement is conditional upon the employer acquiring a leasehold interest of not less than 99 years by either Site A, Site B or Site C. Now, there's nothing in this contract which obliges the employer to acquire any leasehold interest. And the contract only becomes unconditional if it does acquire it. So we can see that this is a contract which is entirely in the control of the employer as to whether it even comes into effect unconditionally. I think I'm right in saying it's been said, it seems to be common ground that the employer is obliged in some way to select one of the works options, although it's not clear to me when he has to do that. But he only has to do that, of course, if he has acquired the leasehold interest under 1A1.
Well, I think the obligation comes from the employer shall give notice to proceed.
Yeah, something like that, yes. But
I suppose you'd have to say what, within a reasonable time or something along those lines.
Something like that, I guess that has to be, yeah. But anyway, that's all academic because he doesn't have to do it, and essentially, unless he wants to, because he just doesn't buy the land. And then Article 2 is just about paying the contract sum or such other sum shall become payable. And then Article 3 is it appoints Peter Black of EC Harris as an agent for the employer. And you may have seen that it was EC Harris who issued the instructions on behalf of the employer. And I think it's also interesting to look at Article 10.
Article 10.
Article 10. Oh,
We're going to have to go back to B.
I'm sorry, it's in B.
In what?
It's Article 10 in this agreement.
I think what's happened is that what we have in Bundle B is the complete contract. What we have in the supplementary bundle is extracts of it.
Oh, I see.
Ah, right, yes.
All right, so we're going back to B.
Sorry about that.
Oh dear. Right, just remind me which tab was it in B?
It's tab 20.
20. Article 10, yes.
Article 10, where there's a discrepancy or conflict between the contract documents, the priority of the document should be as follows. This contract, conditions as amended by Appendix A, the supplementary provisions and appendices. Fourth, the employer's requirement, contractor's proposals. And fifth, the contract sum analysis. And that's important in my submission on the argument, which I understand the argument for the LLPs, which is Clause 12 operates only by altering the employer's requirements. But they say, if you alter the employer's requirements in a particular way, that has the effect of altering the works and the contract sum, because you have to alter both of them to make this work. And in my submission, this provision makes it clear that that isn't the case, that the contract, which provides for the contract sum, takes precedence over any contract sum analysis or anything in the employer's requirements. So it's impossible to argue that by simply putting a contract sum analysis in employer's requirements that you've introduced, that you can vary the contract sum. We shall also see that there's a provision that says the contract sum can only be varied in accordance with the express provisions of this agreement. And of course there are a number of express provisions which allow the amendment of the contract sum in the agreement. Typically it would be a case where we'll look at this, where the employer has issued a change order, which happens frequently, to alter the works, and the contractor says, oh, that's going to cost more.
Well, suppose it was a factory that you were going to build and the employer said, I want an extra story to be put on the factory. It's obviously going to cost the contractor more to build.
Or if they have to alter things, because I think Mr. Cosman said a typical example would be that they found a Roman temple or something.
Yes.
And they have to alter the construction to take account of it. That may cost more. And there are provisions in clause 12 as amended which allow the contractor to go through a process to say, I need more, the contract sum has to be increased. But what it doesn't provide for is for the employer unilaterally to alter the contract sum. And you can see why that would be obviously the case, because you couldn't simply give the contractor the power to change what's payable under the contract unilaterally. Wouldn't make any sense. So Article 10, and then I was going to, following that there are the definitions, but I think we can look at those when if we need to come back to one. The other provision that we need to look at, particularly at the moment, is clause 12. But for that, I think we have to start back in the JCT contract, because that's where the operative part is, and then it's amended. So if we perhaps just start, with clause 4
Of the JCT.
of the JCT.
Yeah.
So that is what requires the contractor to comply with all instructions issued to him by the employer in regard to any matter in respect of which the employer is expressly empowered by the conditions to issue instructions. It may not matter, but the words after that have been deleted in this contract.
Well, save that.
Save that words were deleted. It's on, yeah, it's something in the amendments. And then 4.2, upon receipt of what purports to be an instruction issued to him by the employer, the contractor may request the employer to specify in writing the provision of the conditions which empowers the issue of the said instructions. The employer shall forthwith comply with any such request, and if the contractor shall thereafter comply with the said instructions. And then again, the words in brackets have been deleted. The words beginning neither party down to instruction. So it then continues, then the issue of the same shall be deemed for all purposes of this contract to be empowered by the provision of the conditions specified by the employer in answer to the contractor's request. So it does give them a limited right for the contractor to ask, what power have you got to do this? But that's all. So then if we move on to clause 12,
Yeah.
so it starts with a definition. The term change in the employer's requirements, or change, means a change in the employer's requirements which makes necessary the alteration or modification of the design, quality or quantity of the works. Otherwise, in such a reasonably necessary for the purpose of rectification pursuant to 8.4. And that, I think, is simply that is a reference to a case where the materials weren't in accordance with the contract. So it's a particular circumstance. It's not relevant to. So it's then what you can do is the addition, omission, or substitution of any work. Not works, you'll notice. It's work, small w. The alteration of the kind of standard of the materials or goods to be used, and then the removal from the site of any work executed or goods brought thereon by the contractor other than those in accordance with the contract. So if the contractor's brought on stuff that he shouldn't have, then he can be required to take that off. And then 12.2.1, the employer may, subject to the proviso hereto, and clause 12.2.2, and then, as you probably know, the words "and the contractor's right of reasonable objection" set out in 4.1 have been deleted from this. Issue instructions affecting a change in the employer's requirements. No change effected by the employer shall vitiate this contract, provided that the employer may not effect a change which is, or which makes necessary, an alteration or modification in the design of the works without the consent of the contractor, which consent shall not be unreasonably delayed or withheld. A point just to note about this, thinking about the contract sum, you will notice that an alteration of the contract sum, if that were permitted, is not one of the things which requires the consent of the contractor. You might regard that as quite significant. We would submit that that is simply because it's not something which the employer can do. But if it was, then it wouldn't require the consent of the contractor. And then if we just look over the page, you'll see valuation of changes in provisional sum work. Now that is something that is dealt with in this JCT version. However, I don't think it's perhaps particularly relevant, wouldn't be relevant to this kind of work. But what has happened is that there's been an amendment, which if we look in the contract, we'll see that a new clause 23A has been...
New clause 23?
Sorry,
12.3.
12.3A. And
Yeah.
it's, if you're working from the same as me, it's page 570.
Page 51.
And it's clause 12.3A.1. And it's what happens if there is a if the contractor or employer believe that the instruction will require adjustment to the contract sum. So in that circumstance, the contractor will, within 2 working days, give notice to the employer of that fact. And if requested in writing by the employer to do so, the contractor shall not comply with the same, but shall first furnish the employer, within 10 working days of the instruction, his estimates of the value of the contract sum, etc. And then there is a method of dealing with that. But it's important to note that 12.3A.3.1, which is on the other page, opposite page, the employer may nevertheless, even though there's a dispute about whether the contract sum should be increased, the employer may nevertheless instruct the contractor to comply with the instruction, in which case the provisions of clauses 12.4, etc., as appropriate, shall apply. And over the page, the employer may refer the matter for resolution in accordance with 39A, adjudication.
Yeah.
So there is a mechanism. I think it's said, well, this can protect the contractor if there are fundamental, huge changes made. I think the point we made, and it may not matter, of course, whether it's commercial or not, because it's really a question of construction of the term. But if you're looking at the commerciality of it, this requires the contractor to give notice and then to get up what he says ought to be paid for this very quickly. He has to produce the estimates you'll see under 12.3A1 within 10 working days of the instruction. So he has to price the entire job within that period and then provide the information to the employer. And the simple point that's being made is not that it's impossible to do that, but it's very, very onerous.
Yeah.
And unlikely that a contractor would be agreeing to such a term. But the real point about clause 12 is actually simply looking at the wording of clause 12 itself.
Yeah.
So this is really a subsidiary point. So I think those are the important clauses to.
Could you just take it to 12.3A3,
Yeah.
page 52?
Sorry, 12.
3A3, 52.
Right, 12.3A. 2, is that following receipt by the
No,
employer?
next one down. If agreement cannot be reached.
If agreement cannot be reached within 5 working days of receipt.
Sorry, where are we?
It's 12.3A.3.
12.3A.3. If agreement cannot be reached within 5 working days, that?
Yes. Then the employer may nevertheless instruct the contractor to comply with the instruction, etc. And then the employer may refer the matter for resolution to 39A.
Yeah.
Yeah. Sorry, I thought wrong. So the next documents that are relevant, although I don't think they're really any dispute about them, are the 2 amendments or variations that took place in 2009, which are behind tabs 27 and 28. If you're in bundle B.
Yeah, that's in bundle D, I think.
It's in fact they're in bundle B right at the end.
Right.
There may be another version. It may be that in bundle D there's a version for DC3.
Right.
The way this has been structured is that the versions that are in most of the versions are in the
No,
supplementary
I
bundle.
think you're right. I think that is where I looked
Yeah,
at them.
DC2.
Yeah.
So this one allows a combination of works option 2 and works option 3, although I don't think that was ever implemented. And 28 allows a combination of works option 1 with works option 3 by the means of varying the previous variation.
Yes.
I'm not quite sure whether that means the previous one doesn't exist anymore or whether that's just a drafting technique, but anyway, it doesn't matter. So we have the possibility of combining 2 works options. And then we come to the change orders, which are in the beginning of bundle C. So the first page,
Sorry, where are we now?
is bundle C, tab, right at the very beginning, tab 29.
We got one of them, I think, in the core bundle. C tab 29. Yeah.
Yeah, maybe the same one. This is the one for DC2. And the first page is the instruction from EC Harris. It's headed works option number 1 in accordance with clause 23A. We are authorised by the employer to instruct you to proceed with the works in accordance with change order number 2. And change order number 2 is on the next page. That's again headed Works Option 1. And it says, under clause 12 of the contract between Highbridge North Tyneside developer, that's the developer, and the contractor, dated 17 February 2006, we have been authorised by the employer to issue the following instructions. Undertake the design, construction and commissioning of number 1 data centre DC2, totalling 3,600 square metres net technical space, together with support facilities and closed plant. The works will include drainage, external works and services, all in accordance with the employer's requirements, reference draft version, March 2011, and appendices listed therein. And that's a document we don't have. The employer's requirements draft version, March 2011. For the sum of 54,845,150, Shell and Core is to proceed from the date of the notice to proceed under the contract. The date of possession shall be confirmed.
So you say then that it's, because it's Shell and Core, that excludes the fit out.
Yes, it's only about, yes, it's only fit out, Shell and Core, that's right, yeah. Yep. So that's what's being, and you'll see that also from the next page. Details of change at the top box. HNTDOL variation request. And then rather peculiarly it says add as necessary to the employer's requirements for Works Option 1 so as to provide the Shell and Core and number 1 data centre DC2, including support facilities and enclosed plant. The works will include drainage, external services, etc. So you can see that's what it is.
Right. What tells me where it's going to be built?
Nothing in this. In that it would be in the employer's requirements, probably.
Have we got those?
Well, we haven't
What I thought we had, you say, is for the subcontractors.
That is a much later.
Right.
That is a March 2012 for the subcontractors, and it's under the SDAs later on. What we don't have is the document that's referred to in this change order. So it's to be in accordance with the employer's requirements, draft version, March 2011, and appendices. So we don't have that document. So we don't know what's in it.
So what do we do then? Do we go back to the definition of work option 1, which tells us where work option 1 is going to be built? Is that what we do?
Well, that would be problematic in this case because, as I said,
Because you said
at this point
it's already been built.
there's a factory on that. Yeah, there's a building on it.
How else do we identify where this
Also, they
this
don't
document
own the
is going
land
to be
as well.
built?
There's another problem, which is the land would be owned by the syndicate, which is building DC1. That bit of land, because DC1 is the same kind of project as this. Of course, they acquire the land along with the building. So how do they? Well, we don't know from that. You can't tell from this document. You can't tell anything. What doesn't make any sense in this document is the sum that's stated to be paid for the Shell and Core construction work. Because that is, in fact, that should be the price for the entire building works, including the fit-out. That's the price for the entire thing.
Sorry, what is the
54 million is the price that the contractor is supposedly charging the employer for doing all of the work.
Including the fit out.
And in fact, the fit out is the more expensive part of the building the Shell and Core is cheaper than fit out. You can see from the relative figures the price of Shell and Core construction was, you saw from the employer's requirements was 15 million odd. But the total price, because the fit outs can be quite
Yeah.
sophisticated. But the point is that if you just look at this document, it doesn't make any sense at all, because it's a direction simply to carry out the construction work to shell and core. Nothing else. But it's for the sum of 54 million. Now, if the contractor was only obliged to do like that for 54 million, I'm sure he'd be very happy. Although the reality is, of course, they're both in the same group, so it doesn't, they're neither happy nor unhappy. But anyway, it doesn't make any sense. And so, of course, we say this doesn't operate as an instruction at all for the various reasons we've gone into already, and the Upper Tribunal found, and also for other reasons. And it certainly doesn't alter the contract sum. The contract sum under Works Option 1 was, I think, over £100 million. You'll find that in the decision, but it's like 100 million, I think, something like that. So we're talking about reducing it by about half. But then you do wonder what's left, because what the position is after this, because it does say add as necessary. It doesn't say substitute if you look in the next page. So I'm not quite sure really what this is really supposed to be doing. That rather suggests that the original employer's requirements for Works Option 1 remain. Although, in fact, they could never be operated because DC1 is there.
Yeah.
So that was a change order on the 1st of April, and then the last document you can look at is the SDA, the Sale and Development Agreement, which is at tab 33 of this bundle.
Again, I've been using it in
I'm
the
sorry.
supplementary core, and I hope it's complete.
I hope so as well. Can we just check? Does it start at?
Mine starts at page 76 of the supplementary core.
It should have an index, and then
and it runs on to page 363. And it includes, starting at page 267, the services agreement.
Yes. And it has a whole lot of appendices.
It has a whole lot of appendices, which I can't pretend to have read from cover
No.
to cover.
Well, I wasn't proposing to read them myself. I was just going to point out what they were. And some of them have been removed, you've seen.
Yeah.
Trying to cut down the amount
Yeah.
put in. Trouble is, you find the one you remove is always the one that you discover later you need. But anyway, that's life. Well, let's hope we've got everything. So, if we look at the definitions, can I just point to one of them before we look at the operative part, or two of them? Building, which is on the second page, means the building comprising 4 data halls described in the shell specification and the fit-out specification to be constructed on the property by the developer pursuant to the provisions of this agreement, being an aggregate not less than 36,000 square feet lettable area. Slightly strange because it refers to the developer building it, but anyway. Building works means the shell works and the fit-out works, which are all to be carried out by or on behalf of the developer pursuant to the provisions of this agreement. So the building works, and they're all specified in this contract, and said there are provisions for them, are all being carried out pursuant to the provisions of this agreement. I should have mentioned, that the agreement is between you look at the first page, the developer is the first party. The two next parties are simply there because of an option agreement with the LLP, so they're not really important. And then we have the contractor, and then we have the LLP. And now The contractor in this contract is referred to as a principal contractor, because this contract, of course, deals with the subcontracts as well from the contractor. So you'll see a reference to the principal contractor. That is the contractor that we've been talking about. So if we then turn on to clause 2,
You show principal contract on page 85.
all right. Yes. Sorry, the definition. Do you mean principal contract or contractor? Yeah, sorry.
Both, yeah.
Yeah, principal contract. That is referring to the building contract, 17th February 2006.
Yeah.
And the principal contractor is the contractor. You'll see in the next one. So if we then, this agreement deals with a lot of things. It does a lot of things. We'll see, including a lot of things which are only relevant to the cross appeal. But anyway, it starts by saying, but the lease Highbridge Business Park Limited granted a lease of the property to the developer. In consideration of the payment by the owner to the developer of the sum of £1, the developer has agreed to assign the lease. So, and I think there is a draft assignment in the contract. So the lease, the 990-year lease, which I think is a rack rent of the land, is being assigned to the owner is the LLP. So it's being assigned to the LLP under this. And then it goes on to say the developer has agreed to procure the construction of the building and procure the carrying out of the building works for the owner on the terms recorded in this agreement. So again, there's no need to look for anything else. In consideration of the obligations on the part of the developer and the principal contractor to carry out and complete the building works in the manner set out below, developer entering into and carrying out obligations of the services agreement, and then there's provision that the owner grants the developer license to do the work, etc.
Yeah.
And then 2.5, the developer has prior to the date hereof paid to the principal contractor the sum of 54 million. That did happen. So being the total amount due and owing to the developer by the developer to the principal contractor pursuant to the principal contract. Now, of course, that's one of the issues in the case. Was that an amount due under the principal contract? If we are right, then this clause, what is recorded here, is simply wrong. But it doesn't matter, as we'll see. It doesn't make any difference at all. And then in consideration for the developer assigning the benefit of his rights under the principal contract, insofar as it relates to the property, pursuant to the deed of assignment and fulfilling all its obligations under this agreement, the owner shall pay the price to the developer on the completion date. Now, this clause becomes important when we look at the cross appeal, because you'll recall it's all about what this consideration was paid for, and the Upper Tribunal's point was you can see contractually that it was paid for more than just the relevant interest. It was paid for other things. But you can see also here.
Yeah, it says it was paid for assignment of the benefit of the rights under the principal contract, which is what the UT identified as being the relevant interest, and fulfilling its obligations under the agreement.
Exactly, yes. So whatever the position of the principal contract, the developer and the contractor are contractually bound to the LLP to carry out the building works in accordance with this contract. And that would be the case even if the principal contract didn't exist at all. It never existed. Now, what this contract goes on to do is provide a framework for, amongst other things, provide a framework for the building works and selecting contractors, as subcontractors, putting out a price, etc. So, for instance, there are provisions in relation to both the shell contract in 5, what the principal contractor has to do, and then the fit-out contracts, which obviously are not happening at the moment. what they're obliged to do under those.
Sorry, where are you going now?
The fit-out contracts is clause 6.
Yeah.
And there are draft fit-out contracts in Appendix 5, the fit-out
Yeah.
contract, and there's a construction contract for the shell contract. Shell specifications are Appendix 13. So everything is dealt with. It also does a lot of other things, as I said, which we don't need to look at the moment, but in relation to the various other agreements between the parties and the flow of funds, etc. But there's a lot in here about the construction contracts, including to the extent of measurement of floors, clause 11. And then if we look at clause 14, the principal contractor and developer shall procure that the shell works are commenced on or before 31st December 2011, and the shell works are defined as the design, erection and construction of the works referred to in the shell specification. And that's the specifications and drawings referred to in Appendix 13. And then 14, going back to 14.2, the developer shall procure that the principal contractor and the principal contractor shall procure that the shell contractor carries out the works necessary to implement the recommendations contained in the environmental report. And then the developer shall procure that the principal contractor shall proceed diligently with the shell works and use all reasonable endeavours. And the principal contractor shall procure that the shell contractor shall proceed diligently with the shell works. So all the obligations are there to carry out the works, and as I say, all the details are here in the various appendices, which set out the draft contracts. So
Yeah.
So we say, well, it's true that the parties believed that there had been an instruction, valid instruction under clause 12. Don't think there's any doubt that they genuinely believe that. And that's recorded here. But even if it's wrong, it doesn't matter. So that's all I was going to show you at the moment in the Civil Development Agreement.
Just encapsulate the point you're making. You're saying that the LLP's expenditure was under the SDA and not under any other contract. Is that what you're saying? Or are you saying the developer's expenditure was?
I'm saying it wasn't. The question that you have to answer is, was this expenditure incurred by what this question is, was it incurred under the golden contract?
By whom?
By the employer. It's the
developer.
The developer. Yeah.
Yeah.
So, yeah. Was it incurred under the golden contract?
Yeah, that's what I thought.
We say it wasn't. It wasn't incurred under the golden contract.
Well, your first point is there was no golden contract anymore after the so-called change order. It was a new contract, one way or another.
Yeah.
But you then went on to say, I thought it didn't matter because.
Well, what I say, sorry, my lord, I might be clear. What I say it doesn't matter is it doesn't matter that there wasn't any variation under the change order, either under clause 12 or contractually, which I think are the two ways it's put.
Yeah.
They either say it was clause 12 or they say it was an agreed variation.
Yes.
And I'm saying our case is it was neither.
Well, I follow, but if
Yeah,
you're wrong
and
about
we say-
that, if you're wrong about that, then it does matter, doesn't it?
If I'm wrong about that, then if there is a variation, a valid variation of both the works and the contract sum, then I think if that's right, then I think I'd have to accept that it was paid under that.
Yes, well,
Contract.
yes. I mean,
Yeah.
that's what the UT said. They rejected the clause 12 argument, but they said nevertheless,
Yeah, exactly.
there's been a variation, consensual variation, not amounting to a rescission.
Yeah. But my point about the SDA is, I can be right about the fact that there's no variation, and that causes no problem commercially.
Oh, I see what you mean. You mean even if there's no contract anymore, it's all saved by the SDA because
Well, yeah,
that's
exactly.
a sufficient definition of who's to do what. and
Exactly.
what they're going to
And-
get paid for it.
In fact, it goes further. I mean, the SDA actually provides specifically that things are done under this agreement
Yeah.
continually. So yeah, that's the point I'm making. I'm not saying that the SDA itself does anything, but
Right.
it just
I'd misunderstood your point.
it deals with any point that's being made that you have to construe these variations commercially in order to make sense of them.
I follow.
And in my submission, they have no practical commercial significance whatsoever.
Well, doesn't that follow as a matter of basic logic? If the analysis is that you're putting forward is correct, that they're simply substituting a new contract for the old contract, then you operate under the new contract.
Yes. But in fact, even then, that's right. But even then, they actually operate under the SDA. In fact.
Yeah, there, which is the thing.
Yeah. So, sorry, the other thing I was going to show you, but I think we already maybe have shown you, was the later employer's requirements, which we have looked at. It's just to make the point, which I hope is obvious, that they are employer's requirements in relation to the shell and core work. You can see that from them, from the requirements. I don't think there's any doubt about that. And so insofar as it could be said that the original report, the ones referred to in the change order, were similar to those, then you would assume that they were also simply for the shell and core work. And further, if there was any contract sum analysis in that employer's requirement, which we don't have, it would be in relation to the shell and core work alone. So then, can I take you now to the legislation? I'm going to look at it in more detail when I come to my submission. So what I was proposing to do at the moment was just to, first of all, show you a press release as a background that was issued at the time that these provisions were first brought in. It's partly for background, but partly also to explain. They set out quite conveniently what the effect of the EZAs was beyond capital allowances. In other words, what the other benefits of it were. So you can see the whole picture. And then I was going to look at the provisions, but just to explain how they fit together, which I think perhaps if you've read the Upper Tribunal decision, then it might be already clear to you. So can we just look at, it's in Authorities Bundle C, tab 47. Which is this is the press release that was issued on Budget Day in 1980. And as we shall see when we look at the legislation, these EZAs were introduced in the Finance Act 1980. And you'll see a proposal on an experimental basis of half a dozen enterprise zones. It is slightly ironic that yesterday, as I was walking out of into the hallway in Chambers with a television set that the government were talking about introducing enterprise zones.
Certain amount of deja vu.
So I'm expecting in about 40 years we might be back. Not me. Someone might be back litigating.
Yeah.
Small sites up to 500 acres, private enterprises will be positively encouraged by reducing the burden of government supervision and fiscal demands. Sorry. The sites chosen will be areas of physical and economic decay where conventional government policies have not succeeded in regenerating self-sustaining economic activity. They certainly didn't mince their words in 1980. I'm not sure that they would use that language now in describing areas. Anyway, and the measures, you can see that there's a number of areas, and there was going to be one in Scotland, one in Ireland, one in Wales, and a number in England.
Are we the Tyne and Weir one?
Well, this one was much later, because you think this is 1980. This one was designated in 1996.
Right.
So I don't.
There might be another one in Tyne.
There might be another one. Yeah. I'm sure there were a few, but these were the initial few. They'll be designated for an initial period of 10 years, subject to renewal. Both the new and existing firms in the zones will benefit from the following measures. And so here we have a description of the measures. Now, there is actually a slightly expanded version of this a few pages further on. For some reason, it's been written out twice. But I wonder, it might be more convenient to look at that. It's on page 977.
Yes.
The benefit from the following measures: exemption from development land tax, now long gone, 100% capital allowances for commercial and industrial buildings, exemption from rates on industrial and commercial property, local authorities will be reimbursed, simplification of planning measures, and then it describes how that's to work. Establishments within enterprise zones will be excluded from the scope of industrial training boards. Applications from firms within enterprise zones will, for the customs facility known as customs warehousing will be processed as a matter of priority. Any remaining requirements for industrial development certificates will be abolished. The government will reduce to a bare minimum its requests for statistical information. So it's intended to promote growth, I imagine. Who knows? It's intended to reduce the burden on these areas. Now, all of the other measures were time limited to the period of the enterprise zone, the 10 years. So the exemption from development and land tax and all the other things. And of course, the idea was to stimulate economic activity in these areas. Now, not in 20 years' time, but to stimulate it in the next 10-year period. So the idea was to encourage that activity to take place in the 10-year period. Bringing investment in that period. And I would submit that's significant when you look at the provision that we are really focusing on, which is section 298, which is a form of transitional provision in a sense. It's a kind of provision that's often introduced when tax provisions are abolished or taxation is introduced in a particular area. They will often say it doesn't apply to contracts entered into within, before the changes takes place. The idea being that if you are committed to something within the period, then you shouldn't be taken away. You should be allowed to carry on with it. So that is the broad policy of it. We would submit. Yeah. It's not to encourage buildings to take place 20 years after the beginning. That is we would submit to misunderstand the nature of this provision. The starting point is the 10-year period. But the recognition is that parties will have entered into contracts which may take years to come to fruition. or to be built, payments may not be made, expenditure may not be incurred for years after the contracts were entered into, because it takes a while to, building contracts take a while. That's the policy we would submit, 298. So then can I take you to the legislation? We have the history of this legislation in here, and there is a reason for that. I'll come back to that when I'm making my submissions. We say it's significant what the legislation said before the rewrite took place in 2001, because the legislation that we're looking at it was in fact the first tax rewrite project.
Right.
Yeah, 2000. This was the first one, I would submit that it's relevant, it's permissible to look back. Now, I understand Mr. Williamson may have some objections to that, but he can make those objections when we come to my submissions. For the moment, I just want to note what the history was of the legislation.
What were you being told with the tax rewrite that we shouldn't be looking at?
Well, what can I just summarise it in 2 sentences? What this court has said a number of times, including very recently, is that if there's an ambiguity in the provision, then you can look back to resolve the ambiguity.
Well, I think we're told to treat it in the same way as a consolidation statute, aren't we?
Yes, well, except that as we shall see, and you may be aware, there is a difference between that and what I would call a traditional consolidating statute, certainly in tax. Because in tax, what would always happen is you had let's say, the 1970 Income and Corporation Taxes Act, and then over the next 18 years, there would be amendments to that in Finance Acts. And then 1988, they consolidated, but by repeating in the same language all the provisions.
I thought Lord Carnworth had approved observations of Mr. Justice Sales, saying you treat it like a consolidation statute.
Exactly, but it's exactly Mr. Justice Sales that was referred to in the recent Court of Appeal case, precisely. But the difference between a normal consolidation in tax, as I say, at least in tax, is that you don't have this problem of it being rewritten because the legislation is in the same form.
Well,
so
that's true, but
so there's no point.
The reason it's being rewritten is so that people can understand it without going into all the archaeology of the whole thing.
Well, that's exactly. But there is a tension here between that problem, but also the question about whether the law is changing.
Let's not argue about it now.
Yeah. But anyway, if I could just show you the legislation.
Yeah.
Before you do that, Mr. Hewitt, I'm sorry to complain,
Yeah.
but all my bundles of authorities are breaking.
Oh, sorry.
And if it would be possible for the people behind you kindly to supply me with at least 2 fresh bundles, I'd be very grateful.
Yeah.
Because every time I try to turn to the legislation, I can't. It just, the bundle collapses.
I understand. This is a bit of a problem always. Some people insist on having things single-sided. So all the bundles, I think, are single-sided.
But they're also overloaded.
I'm afraid my answer to that is simply to double-side it. So I'm afraid, so my bundles are a bit more manageable, perhaps, simply because of that. But that's a bit of a confession to make. Do you need one temporarily? Because we do have a lever arch file.
Now, I'll struggle on, thank you, but...
I wonder whether it might be, an idea to remove the legislation, because it's a very short part, but you might have to look at it. And put
That's probably a good idea.
If you want to put it in this, just for convenience.
Oh, thank you. That's very kind of you, Mr. Hewitt. Thank you so much.
Right, where are we going? Tab
Right,
3?
it's tab 1.
Tab 1.
In fact, the reason this is here is because this is the Capital Allowances Act 1968 initial. This is allowances for industrial buildings. what happened in 1980 was that they amended this to bring in enterprise zone allowances. So you have to have this in mind. There was an allowance for industrial buildings, but it was at that stage it was 2/5.
Yeah.
And in fact, it previously was 3/20. But that became 100% for certain ones. So then, if we turn on to tab 2, this is the Finance Act 1980. And it's the provisions, enterprise zones at the bottom, section 74, chapter 1 of part 1 of the Capital Allowances Act shall apply with the modifications specified in Schedule 13 to this Act in relation to capital expenditure on the construction of an industrial building or structure, and shall, as so modified, apply also in relation to qualifying hotels or commercial buildings. And then it says, in any case where the expenditure is incurred or is incurred under a contract entered into at any time when the site of the industrial building or structure, qualifying hotel, etc., is in an enterprise zone, being a time not more than 10 years after the site was first included in the zone. So that's the equivalent of what's now become section 298. And then there's definitions of enterprise zone. And then it then says, in subsection 7, the Taxes Act shall have effect as if this section and Schedule 13 were contained in Chapter 1 of Part 1 of the 1968 Act. And then we have Schedule 13, which is on the next page, which is pretty short. So they substitute for the reference to, at that stage it seems to become 3/4, but anyway, you're substituting the whole of the expenditure. And then there's writing down allowances provided. And so that provision as amended in that way was then consolidated in the 1990s.
So under section 74, provided that the contract was entered into in the 10 years, there was no long stop date. Is that right?
I think that probably was right originally. I think that came in later.
Because when we look at 298, there's a long stop date.
Yeah, the long stop date came in a couple of years after this.
Right.
Because I think by the time we get to the, is that the case? 1990? No, I think it came in after 1990, actually. Because when we look at the 1990 Act, which is tab 3, so this is what I meant by sort of traditional consolidation. They've used the same words. They've just brought it into the main part of the Act, so it's consolidated to the 1990 Act. So it's actually sub 1. It's section 1, subsection 1. It's what we've just been looking at in relation to which was in section 74.
Yeah.
I think it was a few years after 1990 that they then introduced a 20-year limitation. Possibly because it was going on too long in some cases. But initially it was just an exception to the 10-year period. And then if we look at the current legislation, which the legislation in force at the relevant time, tab 4. We've put in section 5, which tells you when capital expenditure is incurred. As soon as an unconditional obligation to pay, but that is subject to subsection 5, where it's not required to be paid until more than 4 months. And then it's incurred when it's paid.
Yeah.
Which would cover most cases probably. And then the turnover, we then go on to chapter 3, which is provisions about EZAs, general rule as to what is a relevant interest. The relevant interest in relation to any qualifying expenditure is the interest in the building to which the person who incurred the expenditure on the construction of the building was entitled when the expenditure was incurred. So that helps you.
Now that, in our case, that's the developer, is it?
Well, it would be the developer to begin with, but then then it's also the LLP.
Well,
Because they acquire the relevant interest.
they do, but if we go to 296,
Yes.
you've got to have expenditure incurred by a developer, and then the relevant interest is sold by the developer. So I took that to mean that the relevant interest that we're
Yes,
looking
I suppose you
for
would
is
look
the
at it. It
developer-
is also, yeah,
is the developer's interest,
yeah,
which he then sells to another.
and they acquire the relevant interest,
Yeah.
but it's defined by reference, I think you're right, to the expenditure. So in this case, it would be the contractual rights held by the developer.
Yeah, well, that's what the UT said, and I hadn't thought there was any appeal against that.
Yeah, no,
Yeah,
that's right. So, as you rightly say, my lord, that the provision we have to look at is 296 and how that interacts. And you have to, the UT have explained this, but the effect of 296, 298 and 300 is that in order for the LLP to qualify for their expenditure on the relevant interest on acquiring it, the expenditure by the developer has to qualify. Or it would qualify. I mean, they can't actually claim the allowances, but it would qualify.
yeah.
Because that is then expenditure on the construction of an EZ building. But the provision that we to focus on is section 298, subsection 1. And the time limit for expenditure on the construction of a building on a site in an enterprise zone 10 years after the site was first included in the zone, or if the expenditure is incurred under a contract entered into within those 10 years, 20 years after the site was first included in the zone.
So the contract in question has got to be the golden contract.
Yes, in
For
this
these
case.
purposes.
In this case, yes. Yeah, and yes, I will obviously come back to this, but essentially, we say that the reference to the contract is tied to the expenditure on the construction of a building on a site. But I think, as I understand it, the LLPs say the contract referred to in B can be any contract at all, as long as it is then subsequently varied to be a contract to build a building in an enterprise zone.
You mean you could have a contract for the sale of goods made to be, and then you vary it to a building contract, and that qualifies?
Well, that seems to be the logic. It's difficult to see what qualification there is in this provision, apart from the one which the revenue suggests, which is that the contract is referring to the contract for the expenditure on the construction of a building. And the expenditure is the expenditure referred to in the first part of subsection 1. So we say
Yeah.
that is the ordinary and natural meaning that limits it.
If the expenditure, meaning the expenditure on the construction of a building on a site in an enterprise zone, that's the natural reading of it.
Yeah, yes. Well, that's what we say. But I cannot find anything in the LLP's argument which suggests any limitation on the contract at all. As I say, as long as it can be turned into a contract for construction of a building. Of course, on the LLP's case, any contract could be turned into anything else. Presumably, all you need to do is have a provision allowing it to be a provision like clause 12, I suppose they would say.
You wouldn't even need that.
Sorry?
You wouldn't even need that.
Even that, you just agree Yes. As long as your intention was to be able to obtain the allowances, then you can vary the contract any way you like, I think, according to the LLP's case. I mean, that's where I'm going next, which is the case law on variations and rescission.
Yeah.
Because this is the heart of the case put by the LLPs and accepted by the Upper Tribunal. And we have to look quite carefully at the cases in which they rely. The Upper Tribunal quotes certain passages from these cases. They don't discuss what the context is of these passages and what is actually being said by the courts in them. So it's the same authorities bundle. I was going to start with Morris and Barron.
Yep.
Now, this is a somewhat convoluted, this case. I don't know if you've looked at it. Can I just tell you what happened? Because I think it's quite important to understand that. There was a contract under which the appellant in the House of Lords sold to the respondent, contracted to sell 500 pieces of cloth. The appellant only delivered 223 pieces. That was in September 1914. In March 1915, the appellant sued for the price of the goods that were delivered, which was £888.43. The respondent counterclaimed for damages for failure to deliver the other 277 pieces. That was in March 1915. In April 1915, the parties agreed a settlement of that action. And on 22nd April 1915, the respondent sent a letter to the appellants setting out the terms of the settlement. And that, you can find that letter reproduced on page 78 of the bundle, page 7 of the report. And the effect, what that letter said was that both parties would withdraw their claims and pay their own costs. The appellant was to pay £30 to the respondent to meet expenses incurred through not meeting the order. The account is to be left over, and so no payment demanded for 3 months, to give the respondent the opportunity to sell the goods which had been delivered. The goods not delivered to be kept by the appellant for the respondent if the respondent asked for them, and the respondent to have the option to take up the pieces which had not been delivered, giving time to make, it says. So that was the agreement. Now,
So this is sent by the respondent company.
yes,
Yeah.
and it reflected the agreement that had been made, and I think it was held or it was agreed throughout that this did reflect the agreement that was actually made.
It was actually, the point was that it was an oral agreement and therefore wouldn't necessarily...
Well, the problem was, it was actually, I think the problem was, although it was in writing, it didn't comply with Section 4 of the Sale of Goods Act at that time.
There's a memorandum. It had to be, the agreement had to be in writing.
I think the agreement had to be, well, I think it wasn't signed by
Probably wasn't signed properly.
the other party.
Right.
So, and you'll see in the case that the courts regard parole agreements and agreements in writing which don't comply with Section 4 as being the same, because they're both, neither of them comply. They don't comply with Section 4, that's the only issue. It seems to have been a massive industry, Section 4 of the law, Sale of Goods Act, and the previous provision, which was Section 7 of the Statute of Frauds, I think. I'm not sure what point these were abolished, but I mean, lawyers must have made an absolute fortune from them. There's case after case after case.
I think it was one of the first to go. Section 7 was one of the first to go.
Yeah. But anyway.
Section 4 is still with us.
Is it really? Not for all sales of goods.
It guarantees.
Guarantees, okay, right. But anyway, at that time, Section 4 applied to all contracts for the sale of goods. And so it was a very common issue to have as to what the effect of a parole agreement. I'll talk about a parole agreement, but I actually mean by that when it doesn't comply with Section 4. What was the effect of that? So that was partly what this case was about. But anyway, it carried on. This wasn't the end of it, of course. The 3 months extension of credit expired in July 1915. Later in July, the appellant wrote asking for payment. The respondent replied saying they'd be happy to pay if the appellant delivered the 277 pieces that were due. The respondent wrote again in August, repeating what they said in July and asking for delivery of the balance. And then they continued to do that in September. And then in February 1916, the appellant issued a second writ for payment of the £881. Astonishingly, I don't find this very difficult, the respondent admitted this, but counterclaimed for damages on delivery. So the only issue in the case was the counterclaim by the respondent, and the problem was...
The appellant hadn't signed the memorandum.
Yes. So they couldn't rely, I think it was common ground.
That might have been enforceable against the respondent, but not by the respondent.
I'm not sure it was. I don't think it was enforceable at all. Actually, if you didn't have a proper, if you didn't comply with the statute, I don't think you could enforce it. But it was obviously a lot more complicated than that, because then the question was, could you vary a contract?
Yeah.
A written contract of parole, could you rescind it? Now the judge, Mr. Justice, I think it's Balak, but I'm not quite sure how you pronounce that. In any event, he held that the respondent couldn't exercise the option for delivery, while at the same time refusing to abide by the terms of the arrangement to pay for the goods already delivered. So he essentially said he was, having it both ways. A further point was raised, but not argued, before the judge, was that the new contract could not be enforced by reason of Section 4 of the Sale of Goods Act. And there was a very peculiar procedural history in this, which is summarised in the judgment of Lord Dunedin in this case, as to what actually happened. It sounded as, well, you'll see it, but it sounded as though counsel, having lost, stood up and said, I've got another point. Anyway, it didn't get dealt with. The Court of Appeal held that the settlement agreement, the 22nd April letter, was a contract for the sale of goods, which was unenforceable by Section 4. However, it went on to hold, following a case called Noble and Ward, which you will see referred to in this case throughout, that an unenforceable contract could not rescind the original contract. Therefore, the original contract remained in force, and therefore the respondent could succeed. The House of Lords restored the judge's result, but not for the reasons given by the judge. But importantly, it reversed the Court of Appeal's decision that holding an unenforceable contract, could rescind an enforceable contract where there was a clear intention to rescind rather than intention to vary. A parole contract cannot vary a written contract, and the reason for that is all the terms were not therefore in writing. So if you tried to continue to enforce the contract with the variation, you couldn't enforce the varied terms. However, it could rescind a written contract. And they held, in this case, the parole agreement did rescind the written agreement. It meant the respondent couldn't maintain the counterclaim, which had to be based on the parole agreement. Because the first agreement had been rescinded, and he couldn't rely on the second agreement because of Section 4 of the Sale of Goods Act. However, the appellant still had to be paid for what he delivered because they'd already admitted that. Yeah. He was liable. So that's the background to all of this. And then if you look at what how the judges dealt with it, So Lord Finlay's first. Now, much of this judgment isn't particularly relevant to this case because it's dealing with the other points that I've been referring to. I can just show you, after looking at the facts, at the bottom of page 79, Lord Finlay deals with how the judge had decided it, and he endorsed the reasoning of the judge. So you'll see, he said, I agree with the decision of Justice Bailick on the contract of April 22nd. The objection was also raised, raising in section 4, this point wasn't argued.
Sorry, where are you? 79?
Sorry, sorry, my lord, I've gone to 80.
Sorry?
The bottom
80.
of 79 is where it starts. The counterclaim was based before Mr. Justice Bailick solely on the agreement. The bottom of page 80,
Right.
the paragraph that is one sentence.
Yes. Right. So
For these reasons, I agree with
that's
the
the
decision.
new contract enforceability point. Yeah.
That's the point about, yes, exactly.
Yeah.
Can't have it both ways. He then refers to the objection under the Sale of Goods Act. It wasn't argued before him, but it was fully argued in the Court of Appeal. So he goes on to deal with this, although in some ways he could have stopped there, but this was the important point in the case. The really important point was whether you could rescind a written agreement with an oral one. So he then says, it was contended on behalf of the respondents that the new agreement was not an agreement for the sale of goods, but for the settlement of an action. But he then rejected that and said it was a contract for the sale of goods. And then he says in the next paragraph on page 81, the Court of Appeal treated the case of Noble and Ward as having decided as a matter of law, a case where the fourth section applies, the original contract cannot be rescinded by a contract not complying with the section.
Yeah.
And so for
like
the
that.
next...
He doesn't like that either. He says it's a question of fact.
He then says that's not what was decided in Noble and Ward, and that it is possible. So he deals with that argument for the next 2 pages, and if we pick it up at page 83, the paragraph at the bottom, page 83, the evidence in the present case points to the conclusion that the parties intended not merely to vary the original contract, but to set it aside and substitute another for it, giving a mere option to take delivery of the parcel undelivered. This is the effect of the language of the memorandum, and it was on this assumption that all the subsequent dealings and correspondence of the parties proceeded. And it then says rather ruefully, it's true that neither party adhered to its terms. And then over the page, the paragraph beginning, is the law such as to prevent the effect being given to the intention of the parties to treat the original contract as rescinded? And then he describes what Noble and Ward decided. And then he says, further down that paragraph, about 5 lines from the bottom, the non-enforceability of the new agreement would no doubt be a very material fact in arriving at a conclusion upon the question of whether the new agreement, without performance, was taken in accord and satisfaction of the old. But it seems to me to be immaterial when once this has been established in point of fact. In the present case, the parties, in my opinion, took the new agreement, such as it was, with the other terms of settlement in accord and satisfaction of the original agreement, and there's nothing in law to prevent them from doing so. The respondents must therefore stand or fall with the agreement of April 22nd. And then he says, well, they can't. Anyway. What Lord Finlay is talking about, I would submit here clearly, is the intention of the parties as revealed by what they say in the contract. The language of the memorandum of April 22nd. It's not what they had in their minds, what they were wanting to happen, what they desired. It was what you can see objectively from what they said and did. And then Viscount Haldane says he disagrees with the judge. So there is a bit of a split in the House of Lords as to whether they agree with the judge's actual reasoning, but it doesn't matter because they all agree on the result. So he says he doesn't think he agrees with the judge, but he then says, and this is on page 85, in the top paragraph, just about the top hole punch, But I do not think that it's necessary to decide this question, for it appears to me that the effect of the letter of April 22nd, coupled with the circumstances in which it was written, was to extinguish altogether the earlier contract for delivery, the only contract that response could really enforce by their counterclaim. So then he deals with an argument by the appellant. 2 points. One was that they argued that the parole agreement could vary the original agreement. And he says, and then the second point, that's the first point which he's dealing with in that paragraph, or outlining. And then the second point is the top of page 86, just where it says Morris and Barron. In the second place, the appellant argues the respondents are not given an order for delivery of any goods under the terms of the agreement or compromise. It's varied the old contract. Consequently, there has been no breach. So then he rejects the first argument that you can vary it in the following paragraph on page 86. And he says on page 87, near the top, page 87, that rule is that where an agreement is validly entered into which has to comply with the statute of frauds and variations are afterwards sought to be introduced by parole or by a document which does not comply with the statute, these variations cannot be set up even by defendant as an answer in proceedings to enforce the original agreement. This rule was laid down by Sir William Grant and Price and Dyer, etc. But then he goes on to say at the bottom of that paragraph that both Sir William Grant and Lord Lyndhurst intimated the opinion that complete rescission by parole is distinguished from mere variation, stands on a different footing and is outside the principle so established. And then he comes to consider Noble and Ward, or what the Court of Appeal said about it, the next paragraph, which I'm not going to read. And then he goes on to say in the following paragraph on page 88, the important point here is to see not merely what Noble and Ward decided, but what it did not decide. I think it did not decide, as the Court of Appeal appeared to suppose, that an agreement which complied with the statute could not have an end put to it by a subsequent parole agreement. And then he explains why that is in the rest of this paragraph. And then on the next page, on page 89, this is about 5 or 6 lines up on the same paragraph. I think it's quite a long paragraph. He says, even although itself incapable of being sued on, a parole contract may have that effect, i.e. rescission, independent of any further intention which may exist to substitute a second contract. I think the Noble and Ward affirms what seems to result from principle. In such a case, the agreement to rescind must receive effect. And then he goes on to keep discussing Noble and Ward and in the next paragraph. And then at the bottom of page 89, he says, accordingly, while a parole variation of a contract required to be in writing cannot be given in evidence, the very authorities which lay down this principle also lay down not less clearly that parole evidence is admissible to prove a total abandonment or rescission. Now, there is no reason why this should not have been done for the instrumentality of the new agreement, which does not comply with the statutory formalities just as readily as by any other mode of mutual assent by parole. What is, of course, essential is that it should have been made manifest the intention in any event of a complete extinction of the first and formal contract and not merely desire an alteration, however sweeping in terms. Again, he's emphasising the orthodox view that it has to be manifest, the intention, from what you say in
Well, he does say that on the one hand. On the other hand, he talks about the desire for an alteration, however sweeping, whereas some of their other lordships look at the before and after effect and say, well, if it's too sweeping,
yes,
then it can't be a variation. But
yes,
Viscount Haldane seems to think, well, there's no conceptual limit to how far you can alter, as long as you make it clear that that's what you're doing rather than rescinding. So to that extent,
he may be saying that,
they don't seem to me to speak with one voice, if I may say so.
Well, he may just be saying, however sweeping, but it's still not enough to alter the contract. I mean, sweeping is different from going to the root of the contract, perhaps. I don't think he's being very clear there that he's not suggesting you can do anything.
Well, that's my query. The other law lords do seem to suggest that there are conceptual limits to what you can do by variation, but I'm struggle to find one in Viscount Haldane.
Yeah. Okay, well, what he does say, the rest of, just continue, we'll see what he says later on. He deals with prior inconsistent case law then on the issue as to whether you can rescind a contract with a parole agreement, because there were some cases that said you couldn't do that, and those are the cases that are being overruled essentially by this case, particularly Williams and Moss Empires. He deals with those cases over the next couple of pages and concludes that they were wrong. And then on page 92 he says, "My Lords, I've come to the conclusion that what happened in April 1915, as evidenced by the letter of April 22nd, amounted to a complete rescission and abandonment of the old agreement and the substitution of a completely new and self-contained agreement. The letter purports to set out the result of a conversation between the representatives of the appellant and the respondents, which took place just before it, and it is of course the only admissible evidence of the terms then arranged. The proceedings in the old action are to be withdrawn, a sum of £30 is to be allowed, etc." And then he describes what it is in the next paragraph, and then says, "I think," you see that about 5 lines down, "I think that there is here, in the first place, a good accord and satisfaction after breach, which discharge any right of action for damages which had accrued to the respondents. In the second place, I think that although the letter does not, as far as liability on the part of the appellant is concerned, comply with the requirements of the Sale of Goods Act, either as regards signature, or as regards sufficiently setting out the description of the goods or all the terms of the bargain relating to them, it not the less discloses a definite and self-subsisting parole agreement to abrogate altogether the existing arrangements under the agreement of September 24th, which was no longer to be in force. I draw the inference from the letter as read with reference to the circumstances of the case that the new arrangement was to be a complete settlement of the dispute and to initiate new relations between the parties." So I think he's saying there, in the context of the circumstances of this case, that's what the agreement did. He doesn't really have to address, in a sense, the question about how if they were purporting to vary, how extreme it would have to be, because they weren't purporting to vary. I mean, they were purporting to settle an action on the contract and to introduce a new agreement. So I think, but the important thing is that what you come to that conclusion by looking at the agreement, the terms of the agreement, and the circumstances, obviously, the fact that you have to understand the background. But that's all that you do. You're not looking into the minds of the parties to decide what they were doing. And then we have, so that's what Lycan Haldane said. And then we have Lord Dunedin, and he describes what he describes as a somewhat peculiar manner in which it was treated by the parties and in consequence of their attitude of the courts below. And I just want to draw attention to the way it came about procedurally. If you look on page 94, just at the words Baron and Company, he says, "On the learned judge's announcing his decision, counsel for the plaintiff said that he had a point which he'd not be able to bring forward." That's an occurrence, I imagine. Namely, that contract B was unenforceable. Lord Dunedin has already defined the contracts A and contracts B. Contract B, the second contract, was unenforceable under the 4th section, therefore could not be the foundation of a counterclaim. To this, counsel for the defendants retorted that if that were so, he might go back to the original contract, to which counsel for the plaintiff replied that he was prepared to deal with that argument. The matter then dropped. So I haven't been able to locate any reports of these earlier decisions, but anyway. So in the Court of Appeal, the learned judges, having seemingly indicated they were not prepared to agree with the view of the learned trial judge, so the application of the facts to contract B, the plaintiff brought forward his argument that Section 4 applied. This was resisted by the defendant's counsel as appeared from the judgment of Swinfen-Eddy, or Justice Swinfen-Eddy, who says the question is, was the contract of April 22nd an agreement which is within the section ought to be in writing? So one of the issues was whether it was a contract for the sale of goods, the second contract at all, which is held it was. But, was it such an agreement? It is contended by the defendants it was not. The defendants, however, found salvation in the defeat of their argument, for the Court of Appeal, deciding against them that contract B did not fall within the section, proceeded to say that the case was ruled by the case of Noble and Ward, and gave judgment for the counterclaim upon the alternative plea for breach of the original contract A, a view which seems to have been unpressed by the defendants themselves. So it gets stranger and stranger, really. Accordingly, as the appeal now stands before your Lordship's House, the question is first to be decided whether, assuming that contract B is within the section, the present case really falls within the decision in Noble and Ward. And then he says something rather strange. Let me first say, I hesitatingly accept Noble and Ward as well decided in laying down correct law. Now, his reason for that seems to be that it was a decision of Chief Baron Pollock, Bramwell, Channel, Piggott, and in the Exchequer Chamber wills. Because he then goes on to say, now comes the question of what exactly it was that Noble and Ward decided. So having decided it was correctly decided, he then goes on to consider what it actually decided. So there's a strange order to deal with things. Anyway, you might think. But anyway, he goes on to consider what it decided. That's not so easy to determine as might be expected. So then we have a few pages of a discussion of Noble and Ward. And then at the bottom of page 96, he says, "My Lords, I find myself unable to subscribe to this view. The difference in variation and rescission is a real one, and is tested to my thinking by this. In the first case, there is no such executory clauses in the second arrangement as would enable you to sue upon that alone if the first did not exist. In the second, you could sue on the second arrangement alone, and the first contract is got rid of by express words to that effect, or because the second dealing with the same subject matter as the first, but in a different way. It's impossible that the two should both be performed. When I say you could sue on the second alone, that does not exclude cases where the first is used for mere reference, in the same way as you may fix a price by a price list, but where the contractual force is to be found in the second by itself." So I think what he's saying is, if the operative contractual terms are in the second agreement and you can sue on them, it doesn't matter that you might have to look back for some of the other subsidiary terms in the original agreement. That would be a new agreement on the terms of the second agreement, incorporating some of the terms of the original agreement. That's what I understand him to be saying here. But
Yes,
as long as you
there's
can do
also
that,
the question of impossibility of performing both
yes,
comes into it.
yeah, yes, yes, exactly. Well, here we have the rather strange case in that it was actually impossible to perform the golden contract even before the variation, but certainly after it was. I guess he's saying that if applying to our facts, if the variation was to build a different building on the same site, then you couldn't. That would be clearly a case where you couldn't perform both.
Yeah.
And then he goes back to the discussion of Noble and Ward. And then at the bottom of that next paragraph on page 97, he says, Noble and Ward decided that if the second contract fell within the statute, then it could not be appealed to vary the former, but it did not decide that it could not be appealed to rescind. And then he goes on, continuing discussing case.
So just before the bit you've read, he says the criterion is in the question whether what is intended to be affected by the second contract is rescission or variation. So he comes back to the question of intention.
But that is determined. The key thing is, when they talk about intention, they're talking about intention as determined by looking at what's been done, what the contract.
I think you say intention is to be determined by comparing before and after. And if the after is radically different from the before, then however you define radically different, which we may be coming to, then you've got a rescission.
Yes. Or you've got a new contract, which is the first point. And of course, for our purposes, we don't need to go any further. It was important in Barron and Morrison Barron that there was a rescission, because that was what the case was about.
Yeah.
So that's why it was about rescission. But we don't strictly have to go as far as rescission. We may say there was rescission, but it doesn't actually matter.
Morrison Barron is complicated by the fact that you've got the statute of frauds involved, which was a procedural statute which prevented it doesn't affect the validity of the second contract. The second contract is operative; it just can't be sued on. Once you actually get that clear, then there's no reason why the contract couldn't operate to do away with the previous contract.
Yeah.
It's just that you can't enforce the second one.
Yes, and that was the big point being decided in Morris and Barron. That's what the case was about at the time. But of course, that point itself is probably not important anymore.
No.
I mean, I don't know about sales of land.
Well, it still
But anyway,
it does still affect guarantees.
it may be relevant. Yes, okay. So it may be relevant in some circumstances, but in most circumstances, it's not the relevant point. But why this case was being referred to in the Upper Tribunal was, and here, was not because of that point, obviously.
No.
But what he said about rescission on new variation and rescission, or variation on new contract, because what's being fastened on is a continual reference to intention. But of course, you find that in all contractual cases, the intention of the parties is always what you're looking for. But it's not what was in their minds. It's what they said that you look at.
Aren't you basically saying that you're just looking at basic rules of construction of contracts?
Exactly.
Back to
I am.
Lord
That's what I
Hoffman,
say.
and all the subsequent cases. You say, well, you've got to discern whether the parties to this contract intended to substitute the original contract by a fresh contract on different terms, or whether they were simply varying the existing terms of the original.
Yes. Yeah. But the parties can't conclude that question by simply deciding themselves.
Well, then you've got to formulate some sort of
It's a
test.
matter of legal analysis.
Then you've got to formulate some sort of test for distinguishing between new contract and variation. In other words, that there is a limit somehow
Yes.
to what the parties can do by variation.
Yes. And that there are probably different ways. I mean, there are probably different types of situation where the approach might be different, or might come to the same thing, might be different. But the Lord Dunedin approach is probably quite a good one, because I think that covers all the situations where it's a...
Well, you've got others talking about inconsistency, going to the root of the contract.
Yes,
and so forth.
but they're all essentially saying the same thing, I think. Because going to the root of the contract means that these are the critical terms of the contract that you've changed. So if you alter some minor term, then you're varying it. But if you alter major terms, which you'd expect would be the subject matter of the contract, i.e. building something, the price, these are very obviously critical terms. Maybe the period of the
It's a
contract.
question of fact and degree in each case, isn't it? Because you could have a situation where the parties have varied the price because the cost of building materials have gone up, for example, and therefore it's felt that it's uneconomic for the contractor to continue at the fixed price that they'd originally agreed, and so the parties vary it, but it's essentially the same work.
Yes.
It's just being carried out for slightly more money. Then I think it'd be difficult to say that they didn't intend to be abiding by the terms of the original agreement.
Yes. In the context of a building contract, that is probably dealt with within the contracts. That there are provisions to allow that kind of thing to happen in some circumstances. Of course, there might also be circumstances where they can't do it, and it's a fixed price contract, and you're stuck with it. So you can't vary it. If the parties then agreed to vary it, well, there might be a question as to whether it's a new contract. But of course, it doesn't, as we all know. I think this is Lord Justice Toulson's point.
It doesn't usually matter.
It doesn't usually matter. No, it matters in a case like this, Section 4, and the Bennington case. It mattered in, I think, case my friend relied on, Blue Circle. I don't know if you saw that case.
Yeah.
Because in that case, the first contract had an arbitration clause in it,
Yeah.
and the second contract didn't. So it made a big difference as to whether it was a variation or a different contract. Of course, there was no question of rescission in that case because both contracts were performed.
Yeah.
But there's still a question as to whether it was a separate contract or not.
Yeah.
Yes, but it doesn't matter. But it does matter in tax, I'm afraid. And it matters in there are a lot of situations in tax contexts where whether it's a new contract or not makes a difference. Because tax is like that. It has dividing lines. Sometimes you only get relief if you continue to have the same contract. And you can find that you lose the relief if you've got a new contract.
Well, you can see
although
that
the parties may not
the
care.
expert solicitor in the document you took us to earlier this morning was alive to the possibility,
Yes.
albeit on a much more simplistic basis, that it might be said that if you changed the instalment contracts of the standard form JCT to a lump sum, would that amount to a completely sea change in the nature of the purpose of the tax, and gets a certain amount of assurance that it wouldn't.
Yeah.
But depending on the facts and circumstances of the individual case. So it's a point that people were alert to.
Oh yes, absolutely. I mean, it's a point that I've advised on many times in many contexts. I mean, you usually get 1 or 2 a year, this kind of thing. If this decision is correct, it'll be very easy to advise people. You just express your intention in the contract that it should be a variation, and when you're away, doesn't matter what you've done. Yeah. That's the effect of this case, which obviously will simplify advice. Certainly hasn't been the position previously. So it doesn't matter usually to the parties in contracts, because they don't care whether it's the same contract or a different one normally, as long as they know what the terms are. But this is the position, going back to the intention, of course, this is the position, as you're well aware, I'm sure, that I know, Mother, in all contractual questions. I mean, if you're asking whether there's an offer, what the terms of the offer are, you look at it objectively. You don't look at what the offer or has got in his mind. Whether there's an agreement, you look at it objectively. What the terms of a contract are, you look at it objectively. So all of these are based on intention, but it's how they're identified. So Lord Dunedin, if we look at the bottom of page 98, you'll see he says, I now turn to the facts of this case. There has been alleged breach of contract A on both sides, and action raised with counterclaim. Now, the first term of the new contract B is to put each party to withdraw legal proceedings, then to give 3 months' credit to the defendants in the payment of a sum admittedly due for goods already delivered, then to allow them £30 in satisfaction of the expenses, and then lastly to forgo, etc. My lords, it seems to be impossible to come to any conclusion on this, but that the parties agree that the old contract should be abrogated. And the important point here to note, obviously, is that you're looking at the terms of the contract to determine that. I use the word abrogate because I think it's a better word than rescind when you deal with a contract which has been partly implemented. But as regards the authorities, I might as well say rescind. Further, as regards this arrangement, there cannot be restitutio in integrum. The defendants have had the extended credit, have had the £30 placed to their credit, and have enjoyed an option not to take, which if the market had been falling one instead of rising one, they would probably avail themselves of. And these advantages have been enjoyed and cannot be taken away. In respect of these things, the old contract was to be held abrogated. But the judgment of the Court of Appeal leaves the defendants with all these advantages and yet holds the old contracts binding still. And then I think the next part is about the statute of frauds. And section 4, and then on page 100 at the end, he then says he agrees, in fact, also with the judge's approach. So he agreed with it. But they didn't obviously want to decide the case on that basis, because then the point about section 4 wouldn't have arisen. So then we have Lord Atkinson.
Yeah. His test is at page 102 of our bundle.
Yes, exactly, because before then he talks about noble and ward and whether a parole agreement can rescind. He says it can rescind it. And then in 102, he says, moreover, rescission of a contract, whether written or parole, need not be expressed, may be implied and will be implied legitimately where the parties have entered into a new contract entirely or to an extent going to the very root of the first inconsistent with it. I now turn to the new agreement entered into in the present case and contrast its provisions with those of the original contract. And then he assumes that they are correctly set out in the April 22nd letter. And he compares the provisions. I'm not going to read all that, but over the next couple of pages, he compares them, and then he says that in the paragraph near the bottom of 4, it's quite impossible, in my opinion, to reconcile the agreement of April 22nd with that of September 24th, With the exception already pointed out as to price, they're in conflict, and all these material and fundamental provisions go to the root of each of them. It is, I think, impossible to arrive at any rational conclusion as to the meaning, aim, and effect of this new arrangement, other than this, that it was the clear intention of both the appellant and the respondents to put aside in their future dealings the original agreement and to treat it thenceforth as abandoned or non-existent.
Yeah.
And then he explains that it's not an invalid contract, the second contract. And then he deals briefly on the next page with the point as to whether it's a contract for the sale of goods, and says it was. And then on page 106, he says he agrees with the Court of Appeal. The letter amounted to a firm order, notwithstanding it was accompanied by a legal claim to refuse to pay. The resulting opinion is the respondents cannot support a counterclaim based upon the earlier or upon the later agreement. Not on the former because it's been rescinded, not upon the latter because they cannot prove it in a court of law by a note or memorandum. I think, however, the passage before, he didn't agree with the judge's reasoning. So I think it's 2-2 at the moment on the judge's original reasoning. He agreed with the Court of Appeal, who disagreed with the judge. But that doesn't matter. And then he explains why the parties could sue again, because there wasn't a complete accord and satisfaction or something. I think the law may be different now on that. But anyway, he deals with accord and satisfaction and the rest of it. And then we have Lord Parmoor.
Yeah.
And he says, at the beginning, my lords, in my opinion, the determining factor on which this appeal depends is the intention of the parties at the time when the parole arrangement was made in April 1915. This question is one of fact and depends on the conclusions to be drawn from the acts and conduct of the parties. And then he goes on to discuss the parole agreement. And then he says at the bottom of the page, the crucial factor in determining the conclusions to be drawn from the acts and conduct of the parties is the parole agreement. If this arrangement expressed in clear language an intention to rescind the earlier contract in September, it would, in the absence of explanation, be decisive. And then he spends the next 3 or 4 pages discussing Noble and Ward and all the other cases. And then on page 111 to 112, he effectively says he agrees with the judge in his reasoning.
Well, you need to look at page 109,
Judge what treated.
line 4. Necessary further to inquire whether the conditions have been so changed in their essential character there is a substantial inconsistency. That seems to be the test that he's proposing.
Yes, he says it's not possible to lay down any general principle where the alteration is such that the conditions of the other contract cannot be restored without placing one of the parties under a permanent substantial disability. That's a strong prima facie case. And a probability of intention to rescind. Yeah.
Conclusion is that from a business aspect, the 2 contracts were essentially different,
Yes.
which they were.
Yes.
So that's completed Morris and Barron. That might be a convenient moment. I'm going to move on to Bennington's. I mean, I can probably deal with it in a couple of minutes.
Well, how are we doing for time? I mean, I'm conscious that we've been asking you lots of questions. That's holding you up. But
no, once I've completed this, it will be onto the submissions, and we've.
And how many of these authorities are we going to go through?
What I was proposing to delete was British and Bennington, which is also relied on, Samuel and Wardlow to explain that. Yep. The other authorities are only there for, perhaps Shell UK, but it's only a short passage.
Yeah.
The other authorities are there just for one paragraph, which is expressing absolutely orthodox contractual principles. I don't think I'd necessarily need to look at them.
This is your sort of Street and Mountford, Agnew.
Well, there are cases like RS Limited and Mulcahy and Nextfield Housing that they all say the same thing, Arnold and Britain. So I don't think I need to look at them. So that won't take very long, and then I'll go into submission. So I anticipate finishing easily this afternoon.
In the course of my reading into this case, I did come across an Australian case which did apply your 2-stage approach to the question whether something was a rescission or a variation, directly applying Street and Mountford, in fact. It's a case called 7 Cable against Telstra, T-E-L-S-T-R-A, and it's 2000 FCA 350, in case it's of any interest.
Thank you very much.
All right, 2 o'clock.
All right.